All right, everyone, welcome. Thank you so much for joining us today. My name is Whitney Paganowski, and I am the program director at the Down Syndrome Partnership of North Texas. I will ask that everyone please mute themselves, which I think you already did. Great. That just really helps with background noise during the presentation. We are so excited to have attorney Heidi Angel with us today. She's going to be presenting on wills, trust, and guardianship for your loved one with Down syndrome. She will cover important topics such as planning for your loved one's future, understanding different types of legal protections, and steps family can take to provide support while promoting independence. Attendance at this presentation is required for anyone applying for the Texas Bar Foundation grant. I will ask that you please type your first and last name in the chat so that I can take attendance. After Heidi's presentation, we will have time for questions about the Texas Bar Foundation grant. In the meantime, if you have questions during Heidi's presentation, feel free to drop questions in the chat and I will stop her periodically to answer questions. Thank you so much for being here, and I'll pass it off to Heidi.
All right. Thank you, Whitney. I appreciate it. I hope you all were doing what I was doing while all of the slides were going by with all the wonderful things that are happening with the partnership coming up. I'm like putting everything on my calendar to make sure we don't miss it. I'm so grateful to Whitney and Kim and all of the other staff for all the work that they do with the partnership. They're creating great programs, and I'm personally super grateful for them. So I guess I'm looking out and seeing a lot of familiar names, but obviously, I don't know everybody on here. I'm Heidi Angel. I am an attorney with Jackson Walker. I'm a trust and estates attorney, which means I spend my time drafting wills and trusts and doing probate administrations of wills, trust and estate administration generally. And so I do special needs planning as a part of that practice and guardianship and alternatives to guardianship as well. So that's what I do professionally. I'm married. I have two kids. My daughters are 14 and 16. My 14-year-old has Down syndrome, so we are in the thick of the teen programming, which she's loving and I'm loving. It's really been fun. And we've got the virtual cooking class coming up this week and stuff. So anyway, that's all been really great. I appreciate y'all being on here. This is I've done this speak session a couple of times, I think, and so I'm basically going to just run through my basic overview of estate planning, special needs planning, which just means planning for an individual with disabilities as part of your estate planning, and then talk about guardianship and alternatives to guardianship. And then I'll give some more specifics about the funding for this grant that we're excited to have received from the Tarrant County Bar Foundation, specifically to provide some legal services for families who have an individual with Down syndrome in their family. And to do that, we're going to connect with some other attorneys. We have a little bit more to flesh out about that, and exactly it's going to depend on how many people sign up for the program and how many we need, but we'll connect everybody with attorneys as that becomes necessary. So I'll talk a little bit more about that, and Whitney and Kim may chime in as well with some additional information. This is the first time we're doing this. I've done pro bono will clinics before with the Tarrant County Bar Association, but this is new with the Down Syndrome Partnership. And so bear with us as we figure out exactly all of the details about it, although we have a lot of it figured out and are very excited to be able to provide that service. So my little disclaimer, because I'm a lawyer and nothing can be basic and not involve that. I'm giving really general overviews of legal issues and processes that may or may not affect a family's life as an individual with Down syndrome in that family. I couldn't possibly speak to all the individual aspects of everybody's life who's on here, and so I know everybody has some very specific situations, so I'm going to speak really generally just to hopefully, my goal is to educate people about these areas of the law so that they can be good consumers of legal services, so that they can feel empowered when they're looking at handling these aspects of their life that involves an individual who might need some support. So that's my goal. You might have some specific questions. Like Whitney said, please feel free to jump in the chat and ask some of those questions. And then she's going to kind of collect these, like as I'm talking, she'll say, oh, Heidi, I think maybe a couple people are asking this and you might have skipped over it. So we'll have any of those questions that would be kind of helpful to the group. She'll pull out. And then we'll take questions like Whitney said about the specifics of the grant towards the end. So I am going to attempt potentially to share my screen here. I'm not terribly stuck on it if it doesn't work. Let's see, I'll share. I think entire screen, right? Yeah, I think that works. Okay. How does that look? Is that showing? Okay, I got a thumbs up. Okay, and then, sorry, I'm showing my age and my lack of super high techness. But I will see if I can play the slideshow. Sorry, give me just a second, y'all. I will get it. I need from the beginning. Okay, genius. Easier than it seems. Okay, all right. So that's me. We're going to talk about wills, trust, guardianship, and alternatives to guardianship today. And again, like I said, I just really like to give an overview of these legal issues that might be relevant to your lives and the lives of individuals with disabilities. Um, and the reason why I also like to do this, and I see here people that I recognize who have been really involved in advocating for individuals with disabilities. And so part of my goal in educating people from just what I do professionally is that if you're knowledgeable about the laws, you can be more effective as an advocate and in coming alongside self-advocates as they advocate for changes. So I like to highlight some of the things that have happened in changes in the law that have been good. So we'll get to some of that too. And then, like I said, just helping you to become more knowledgeable consumers of legal services and more knowledgeable advocates in these areas. So we'll start with a general overview of estate planning. And estate planning might sound really fancy. Like, I don't feel like I have an estate. Like, that sounds like a lot. But an estate is just whatever you own. It might be a house. It might be a car. It might just be a bank account. So whatever assets that you have, that is your estate. And so from the estate planning perspective, it's how those assets can be controlled when you're unable to do so. So that may be if you were to lose capacity and have a power of attorney document so that an agent can speak for you in the event of incapacity, or at death, your will would speak for you. And so I think sometimes, people go without doing a will because they think, well, I don't have a lot of assets. Maybe I just have, a bank account and that kind of thing. And so, again, I can't really speak to everybody's specific situations, not knowing your assets, but a very basic will, is an important piece of planning, as are power of attorney documents and that kind of thing. So kind of a list of some of the tools and the terminology that we use in estate planning. Obviously, a will is a document that formally indicates who would be in charge of your assets at your death, your executor, and what they would do with them, how they would dispose of those assets to your beneficiaries. Sometimes we use trusts, so like special needs trusts, and we'll talk more about those, of course. Powers of attorney, like I said, those are in the event of incapacity. Advance directive to physicians, giving your instructions in an end-of-life scenario. And then things like life insurance and retirement accounts. This is sort of broadly what we think about when we're saying, let's do estate planning. And so for disability planning, I'm sure a lot of you are familiar with what we always refer to as the lists. So in Texas, we have, these Medicaid services that can be available to individuals with disabilities when they're under the age of 18. The income limits, if it's a program that's income limited, means tested, that would be the parent's income. But once the individual turns 18, that is based on that individual's income. So sometimes the availability and eligibility for those programs can change. So it's important to be on those lists. If you're not, it's through Health and Human Services. And if you kind of do some Googling around, or you can reach out to Whitney or Kim, we can direct you towards that if that's not something you're familiar with. So some of the other, tools that we use in planning for individuals with disabilities would be a supplemental needs trust. Sometimes it's called a special needs trust. Disability advocates and self-advocates are trying to get away from the use of the phrase special needs. But it is sort of the more common way to refer to these kinds of trusts. But I try to say supplemental needs where we can. And it truly is intended to supplement an individual's life. And it's typically, here's the most basic way that these are used, is that you might have a will, again, for whatever assets you have in your estate at the time of your death. And your will would say, if you're married, everything to my spouse, or and if my spouse isn't living, or if you're not married, then it would say, if you have kids, everything to my kids, maybe in equal shares. But anything to this particular child, so to my Emily who has Down syndrome, I would say to Emily's supplemental needs trust. And the reason for that is because if Emily is on some good benefits that are really helping her, if she needed Medicaid, if she needed any particular programs that were means tested, it would be her income that would be considered for that. And if she were to inherit any amount of money over $2,000, she would be kicked off of any benefits that she was receiving at that time, like if I passed away and she received those assets. So I want my will to say everything for her goes to the supplemental needs trust. And then that trust just has language in it that says everything in this trust is exempt for purposes of benefits eligibility. And then the assets in that trust are used to supplement whatever that individual is receiving through public benefits. Now, these can get pretty complicated, and I'm not going to get into the weeds of it, but I just kind of wanted to say how these sort of fit together. For the purposes of this clinic, where we're going to do some pro bono wills, we're going to look at ARC special needs, ARC pooled trusts, and I'm going to talk about those in a little bit, but that's a type of supplemental needs trust. You might have heard of ABLE accounts, and that's also something that people are starting to use more. Those just came around in 2014, so people are still learning more about those, but they've been a good way for individuals with disabilities to be able to save some money, and I'm going to talk a little more about those. Anybody can add just a letter of intent to your planning that just says, here's what it looks like to be in the shoes of somebody supporting this particular individual with a disability, and here is, some of the accommodations that they need. Here are their physicians, their therapists, kind of a guiding letter if you weren't here to be able to give people that information. As a good part of disability planning is also doing person-centered planning. And so I think we've had some people on the Speak series talk about person-centered planning. Certainly the ARC, A Look Ahead conference usually has somebody speaking on that. And so that's an important part of just learning how to support an individual with a disability and letting them, as they become an adult, have more autonomy in that and be able to have that geared towards their needs and their wants as well. And then guardianship and alternatives to guardianship, which we're going to talk about in detail.
Heidi,
Supplemental, yes.
sorry, real quick. Someone asked, does the supplemental needs trust need to be formed before the will starts?
Yeah, so usually as a part of a full estate plan, I would have on the same day, we would have a special needs trust formed and the will at the same time, because the will is going to reference the special needs trust. So it kind of all would go hand in hand. So if you have a will that doesn't have a special needs trust, and then, you come into an attorney and say, I need a special needs trust, they'd probably update your will too, because they need to reference the special needs trust that they just created. So kind of same time. So yeah, the special needs trust is typically funded on the death of the second parent if those parents are married. If they're not, then the two parents might have separate planning and separate special needs trusts. You can have as many special needs trusts as you want to. Grandparents could have one. Everybody can have one, just so long as nobody's directing something, directly to the child. And again, like I was talking about, it preserves eligibility for SSI and Medicaid and other public benefits. And I add here, so I always like to talk about what advocates are doing in this space. The idea of special needs trusts and having to ask a trustee for funding and that kind of thing, trying to eliminate the need for special needs trusts. If there were better programs, if there was better support for people with disabilities, it wouldn't be necessary to jump through all these hoops. But again, currently, this is what the structure is. ABLE accounts. So just briefly to talk about ABLE accounts. An ABLE account is like a 529 account, if anybody has a college savings account for their kids. So it's a tax advantage savings account in the sense that anything that goes into the account grows tax-free. So it has that tax advantage. So a 529 account is a college savings account. A 529A account is an ABLE account. It is intended for individuals with a disability. And I have an old number there, so let me skip to my next slide because I think I updated this one. So the limitations on it now, and of course with our individuals with Down syndrome, this isn't an issue, but for other people, the age of onset of disability has to be before age 46, but the account can be opened at any age. There's an annual contribution limit to it that's linked to the annual gifting limit. So for 2026, that's $20,000. And then there's a limit to how much can be in the ABLE account, which is $100,000, in which if you went over that, it would affect SSI eligibility. You can only have cash in it. And there is a Medicaid payback provision when the beneficiary passes away. Whatever's left in it would go to pay Medicaid back. And so I put that information in there because ABLE accounts can serve a lot of purposes. They can be really helpful, but there are some limitations on how helpful they can be in certain scenarios. So it's why we typically want to have an ABLE account and a special needs trust if there's significant assets to be managing. If you want more information about ABLE accounts, here's a great resource. It's the ABLE National Resource Center, so ablenrc.org. You can compare different states' ABLE accounts. I happened to get one in Massachusetts. That was before Texas had them. Now Texas has them. I've heard a lot of people doing Ohio, so kind of just feel out what some of those options are if you want to open up an ABLE account for your individual with a disability. The distributions from an ABLE account are for qualified disability expenses, which is really broad. It can really encompass any of these: healthcare, transportation, education, technology, anything like that that's related to the individual's needs. So the ABLE account is great. Typically what we're seeing, how we're seeing it used as a supplement to special needs trusts and to SSI, so that the trustee of a special needs trust can make distributions to an ABLE account for an individual with a disability. And then if that individual is able, they can, if they're able to, they could have a debit card to use with the ABLE account. So it kind of gives a little bit more flexibility to an individual that has that kind of ability to handle that with some support. I put on here that it could be an alternative to guardianship of the estate in some cases, and we'll talk more about guardianship here in a minute. But it's just another way to manage assets for an individual with a disability and still protect benefits. So a special needs trust is managed by a trustee. So generally, if you're doing this as part of your estate planning, you would name somebody. I would name my sister. You name a family member to serve as the trustee. For people who have more significant assets, you might name a bank to serve and have a corporate trustee because it can get a little bit more complicated. If you're not self-directed, which means that the individual with a disability can't say what's happening to exactly to the money, they can express what needs they have, and then the trustee makes a decision about how those are managed. It can't pay for food, clothing, or shelter because that's what your benefits are supposed to be paying for. So there's some limitations there, and the Social Security Administration has some review authority over these trusts. And the ABLE account, where we like them, is that they're a lot more flexible. They can be self-directed, so the individual could have a card. They can access the account. It can be managed by an individual, or they could designate someone to be the manager of that account. And it has a much broader distribution standard, so it's a little bit more flexible. But again, it's got limits on what can be in it, and it has the payback provision. So it's kind of a mix of both of these. The special needs trust has to be drafted by a lawyer, right? But the ABLE account, you can open that. You can just go to the ABLE National Resource Center and open an ABLE account. Again, subject to those limits. But I think it can be a really great way to put, some money in there if the individual has, under $20,000 or something like that in a year.
We have a
And then,
question about
yes, go ahead.
special needs trust. When you say anyone can have a special needs trust, grandparents, mom, dad, do they not all refer to the same individual's trust, or does the individual have several managed by different trustees?
So it's possible that they could have several managed by different trustees, whoever is named in each of those documents. And just kind of like you're thinking, that is not ideal, right? It could be that it could be a little bit complicated, but legally you could have as many special needs trusts as were set up. So there's no limit to the number that you could have. Now, I would suggest that if grandparents are wanting to set one up, you might say, hey, we're doing a special needs trust. You could reference ours in your will. So there could ideally there be coordination, but if not, it's okay. It's just how it might end up in some cases. Let's see. Okay, so for the purposes, so special needs trust, lawyer drafts it. It's a part of your estate planning, connected to your will. You name a trustee. So what I wanted to add in here for our wills clinic, this be a pro bono wills clinic, we're going to stick to very very basic wills. So what we're, this is a, the pro bono clinic is going to be um, a, a free wills clinic. So we're just going to make it very, very simple. And so we're not going to do special needs trusts as part of this, but instead of that, we're going to reference the ARC of Texas Master Pooled Trust as an option if you want to avoid having assets go directly to your family member who has Down syndrome or other disability, then instead of a special needs trust, we would suggest the ARC of Texas Master Pooled Trust. And it is a special needs trust, but instead of having a family member serve as trustee, or instead of incurring a pretty high expense of having a corporate trustee or a bank serve, the ARC of Texas does a trust where they pool all of the assets together, and so they can service beneficiaries for a much lower cost. And so it's a really good cost saving option. And so I think that's what we're going to suggest with the planning piece for the pro bono wills clinic here, is that we could say something like, for this particular individual, if they have an ABLE account, or if you plan to get an ABLE account, that up to the limit of the ABLE account, you could make a distribution to that, and then anything remaining could go to the ARC trust. And it is a specific trust at the ARC held for this individual. It's not like it's just thrown into that for everybody, but it's a good option, I think, for this clinic to kind of keep it streamlined. Okay, I really ran through estate planning really fast there. So any particular questions before we move on to guardianship and alternatives to guardianship? All right. So yeah, generally in the realm of planning, if I sit down with a family who has a child with Down syndrome or another disability, we'll talk about that estate planning piece. What do you have in place? What do we need? What do your assets look like? How can we plan for those so that we can plan best for everybody in the family? And then part of that is, dependent upon the age, and just to speak very generally, I'll speak to, parents who have a child with Down syndrome. Sometimes they're young, so we're just doing the estate planning and special needs planning. Sometimes they're about to turn 18. Sometimes they're adults. And so what that family is coming to talk to me about might look differently. Typically, I'm having people come in who have a child who's about to be an adult, they're 17, or they just have turned 18. And so the question of guardianship comes up. And it is very individualized, this question. So there's not really a blanket answer to, do I need guardianship, or can we do an alternative to guardianship? I think there's a lot more alternative to guardianship available than there used to be. And so what I'm going to do first is just walk through the guardianship process, just to give a background of what guardianship is, why guardianship, what does it look like? And then I'm going to talk about alternatives to guardianship, which is really going to be the focus of our clinic that we're going to be doing. Okay. So when somebody turns 18, they're an adult, they have all of the rights that an adult has to open bank accounts, to get married, to vote, to do all of the things that an individual who turns 18 can do. So if there's an individual who does not have the ability to use an alternative to guardianship that we'll talk about, and who's determined by a court to not be able to handle their personal financial affairs, then a guardianship is a court supervised procedure that the court gives a person the legal authority over that individual. So there's two types of guardianship. There's guardianship of the person, and there's guardianship of the estate. Guardianship of the person is basically a person who's appointed to consent to medical treatment is the primary thing. But kind of make decisions about where they're going to live, and depending on what that individual needs. So there could be a limited guardianship of the person if really we just needed somebody to consent to medical treatment, or it could be more substantial if there were more needs. Guardianship of the estate would be if somebody had financial assets. So typically this is a case of maybe an elderly person who loses capacity but had assets, and so now the family needs to have somebody put in place to manage their assets because they aren't able to anymore. Now, if that individual had been able to execute a power of attorney during their lifetime before they lost capacity, then that agent could act for them and a guardianship isn't necessary. But if they aren't able to execute a power of attorney and then become incapacitated, then a guardianship might be necessary. So there's pros and cons to guardianship, and I know probably everybody here has heard lots of different opinions about guardianship. So Some of the pros about guardianship is if there's a person who truly is vulnerable to abuse, neglect, or exploitation, the guardianship can provide some protection. The court-appointed guardian can support what the court calls an award, a person who is under guardianship, by handling their personal business affairs. And then there's court supervision. So you can imagine somebody who, really is someone who is vulnerable to exploitation, whether that's an elderly person or an individual with an intellectual disability who is unable to manage their day-to-day affairs, that this could be supportive and it could be protective. The cons is that it's the most restrictive action that you can take to protect someone, and that individual loses many of their basic rights. So it's not something to be taken lightly. It also requires hiring an attorney. There's about $800 of court fees plus attorney fees, so it can be quite expensive, usually $5,000 to $6,000 for most attorneys to be able to work through a guardianship. You have to go have a hearing and prove up that the individual is in fact incapacitated, that there's a necessity for guardianship, and that this individual that's seeking guardianship is the appropriate person to serve. And then going forward, you have court supervision and involvement in your life. So there's some downsides to guardianship, but if it's absolutely necessary, then it's something to consider. So if it's determined that, no alternatives to guardianship, again, asterisk, we're going to talk more about alternatives to guardianship here in just a second, but if an application for guardianship is filed with the court, then you submit a physician's certificate that describes the nature of the individual's disability and incapacity, and then the court appoints an attorney to represent that individual. And then we have to go to court and prove up all of the elements of incapacity, necessity, and there not being any alternatives to guardianship. And then if it's approved by the court, then the individual who has sought guardianship for the incapacitated person receives letters of guardianship. And then each year they have an annual report that they have to file where they let the court know of any changes, if you've moved to a different residence or anything like that. And then guardianship is county by county. So if you move to a different county, the guardianship has to be transferred to that county court. So that's kind of unexpected sometimes for people. And so I just always like to really emphasize that because guardianship takes away a person's rights, it should be the last and best available choice. So it should be absolutely necessary. Alternatives to guardianship. So we talked about guardianship of the estate would be managing assets of an individual that wasn't able to manage those assets. And so the special needs trust really is a good alternative. So that's why you would put that in your planning so that, a parent, when they pass away and their children inherit from them, it would be inherited in a special needs trust. And so they wouldn't have those assets held outright, which would involve needing somebody else to manage those. For SSI payments, you can designate a representative payee, so you don't need to have a guardianship to receive SSI. You can serve as a representative payee. And then, like I was saying, you can have a power of attorney if that individual had been able to execute a power of attorney. So for guardianship of the person, a supported decision-making agreement, this came along in 2015, I think, that the supported decision-making agreements came along in Texas. They've been a really good alternative to guardianship of the person. Essentially, if the individual with a disability is able to nominate and say that they have an individual that they want to name as their supporter, then they can enter into a supported decision-making agreement, which can help in the sense of it can be given to their doctor, and the doctor can say, oh, okay, this individual who's 18, over the age of 18, they're an adult, they have a disability, and they have asked to have a supporter come in with them, help them make medical decisions, and that kind of thing. And so before supported decision-making agreements, it would have been less available for that adult or that parent to come in and help their adult disabled child make those decisions. Medical power of attorney, again, if an individual had been able to enter into one before losing capacity, then that can be an alternative. And then I just mentioned that if someone is actually in a skilled nursing facility, then there's some surrogate decision-making that can be held, that can happen without a guardianship as well. And of course, if you're in an emergency room, they can treat somebody even without a guardianship because it's an emergency situation. There's also consent to authorize advocacy. I've got that on another slide coming up here, but that's for educational purposes. So you're always kind of thinking about, when it comes to guardianship, who's the gatekeeper? Who's the person that's saying, when this person turns 18, we can no longer accept, excuse me, the parent, speaking for that child or making these decisions. And so supported decision-making agreements typically will bridge the gap from medical. So they'll help, if an individual can actually indicate that they need that parent to help support them in making medical decisions, and that can really help to, provide assistance with those life decisions and communicate those decisions with people and have that supporter named. You don't have to have an attorney to have a supported decision-making agreement. The ARC of Texas website has forms and explanations and videos, and so does Disability Rights Texas. So there's a lot of really good resources out there that you can use to make your own supported decision-making agreement. It's a statutory form, so it's in the Texas Estates Code, and so it's just a form that you can fill out. As a part of our wills clinic, we're going to talk to people about supported decision-making agreements and have those as a form that we can help people fill out. Because we really want to encourage people, if your individual with Down syndrome is able to have a supported decision-making agreement and put off guardianship or not need guardianship now or for a while, that would be a great thing to be able to protect their rights. And then I mentioned this, and I got these slides a little bit out of order, but the consent to authorize advocacy is also known as an education power of attorney. And again, it's just another, this is what that looks like, just another tool in the tool belt for avoiding guardianship, because you often will hear from your school district and your IEP meetings, okay, you need to go get, guardianship because they're almost 18. They're actually required to tell you that there are alternatives to guardianship, and they're supposed to discuss these in that transition meeting in your last or towards the 18th birthday ARD meeting. And so they should be talking to you about alternatives to guardianship. If you have someone tell you that your individual absolutely needs to have guardianship, then you might at least just push back on that and think about the options and see if an alternative to guardianship would work instead. So either a supported decision-making agreement or this consent to advocacy, educational power of attorney, some of these documents or all of them might be helpful just to bridge that gap with people. Again, if your individual is able to understand those documents. And so I just point out that these changes in Texas law happened in 2015, and they really were pushed by self-advocates and disability advocacy groups. And it created these less restrictive alternatives to guardianship that are required by the law to be considered before filing for guardianship. And so you have to consider these. And when we stand in front of the court, if I'm doing a guardianship case, and we'll say, did we talk about alternatives to guardianship? Did we talk about supported decision-making agreements? Did we talk about these things? And we show the court that we did. We looked at all these options. And in this case, we're here in front of the court because they were not sufficient to protect the individual's rights. So we need to go seek guardianship. And then also the Supported Decision-Making Agreement Act and Awards Bill of Rights to protect them under guardianship. These were all pushed through in the 2015 legislative session. So all to say, sometimes, people push and push for legislation, and then all of a sudden in 1 year, you get a lot of really good legislation that goes through. So who knows what the next thing will be, but some of you may know things, that are being pushed forward. And I think it's important to just kind of be aware that these things change. So this was when, in Washington, D.C., when the ABLE accounts were passed. So this is National Down Syndrome Society. A few of us from DSPNT were there in 2014 when the ABLE account was passed, and that was really exciting. It was fun to see that really pushed by disability advocates, and it's made a big difference in people's lives. So things change, things can be done. I think these are all really important when we're talking about any kind of disability planning, to just make sure we're really focused on these other aspects. So person-centered planning that we talked about before. I learned a lot from doing person-centered planning and shifting from thinking about fixing and supporting and protecting an individual to shifting to their self-determination, their ability to steer their own course. their ability to have dignity of risk, to take some risks, to make mistakes like all of us have gotten to do. I'm more grateful for all of my failures than anything that looks like a success, because I've learned every time I make a mistake, I want to run down the hall and be like, I want 10 other people to learn from my mistake because it was so valuable to me to make this mistake. So everybody deserves to get to do that. And so I highly recommend finding somebody to help you with person-centered planning. Read about it, think about. I remember sitting in that and thinking about, and I'm going to phrase it. I know if we were in person, you guys would be reminding me of exactly what the phrase is, but it's looking at what is important to them and not all to the individual with a disability, and not just what's important for them. And as a parent raising a child with Down syndrome, I've thought a lot about what's important for them. And it's important for them, for me to think about what's important to them. And so that's kind of what that person-centered planning does, is it trains us to be better supporters to enable all these other pieces. And then that letter of intent is kind of a good way to put out, your wishes for the individual that you're supporting, so that somebody else could continue doing that. Okay, so, and I'll take some questions about guardianship if you have any. So, send those in if you want to, because I went through that, I know, really fast. And then we'll talk a little bit about the program, and Kim and Whitney can jump in to add to it if you want to. But basically, they're going to take applications, and I'm going to get the estate planning questionnaire over to Whitney and Kim to get that out with the application. So you would submit an application, and the questionnaire basically runs through your estate planning. So if you want to be involved with this as an estate planning clinic, and if you qualify, because there's going to be an income cutoff for receiving grant funding just by the terms of the grant. So if you qualify from the application, then the questionnaire would ask you a bunch of questions. What's your full legal name? Who are your children? Are you married? Who would you want to name as your executor? How would you want your estate distributed? And so it could be just as simple as, everything to my spouse. And then if my spouse isn't living, then to my kids equally. But here's my child that will need the special needs planning. And then once you've given us all of that basic information, then one of the attorneys that's going to work with this clinic will be assigned to your case, and you'll talk with them, and then they'll prepare the documents based on that conversation. And then depending on the number of people who apply, we'll have 1 or 2 wills clinics where we'll sit down and have everybody sign in front of 2 witnesses and a notary, so that you leave with a validly signed, validly executed will. And then based on our conversations from that first, estate planning context, we'll talk a little bit about guardianship and supported decision-making, if that's part of your situation. If it's not, then it won't apply. But if that applies to your situation, then we'll talk about supported decision-making, and then hopefully make that supported decision-making agreement a part of the wills clinic, and a part of you coming in and signing your document. So that would just be bringing that individual with Down syndrome in, who's an adult, who could sign a supported decision-making agreement. And then if it's determined through this process that you do have an individual who may benefit from a guardianship, then we're going to connect with some attorneys who've agreed to work on a pro bono, or what we call a low bono basis, based on a sliding fee, and we're going to have grant fees applied to that to cover court costs. So again, depending on how many people apply and fit within the income guidelines, we're going to give some options for attorneys that you can work with, who have agreed to work with us. And we've had several that have been very generous with their time and are excited to be involved with this clinic. So, any questions? I always run out of time, so I tend to go so fast, and I apologize. It's a lot of information to take in. So
Let's see. I think we have some questions in the chat. Amy says, does limited guardianship cause the individual to lose some rights?
yeah, so it could be limited. Usually if it's a limited guardianship, what we're looking at is consent to medical treatment. That's usually the main thing. And so when we say limited, usually the ones that we try to not take away if we don't have to is like your right to marry, vote, and carry a firearm, are kind of the optional, I guess, ones that can be added on or excluded, just depending on the situation. And so, truly, a limited guardianship is typically because we're needing somebody in place to consent to medical treatment.
Okay, Nicole asked, can you have supported decision making and also have power of attorney over medical and financial?
So it's an interesting question, and it really depends. I mean, technically, yes, is the answer. It depends on the individual. And so if I'm working with a family and I'm, talking to them about whether this individual can sign a power of attorney document. In order to sign a power of attorney document, you have to have the legal capacity to enter into a contract. And so many people with intellectual disabilities may have that ability, but some don't. And it's really kind of a difficult line. It's really not my job to determine whether somebody has that ability, although I know whether, if it's an elderly person, it's a little bit easier than sometimes our friends with Down syndrome, because sometimes communication is really the issue and not necessarily intellectual disability, at least when you're trying to figure out whether they understand the document that you're asking them to sign. And so it's important to not just stick a document in front of somebody and tell them to sign it. It's important that that person has the legal capacity to do so. And so if we're not sure, if somebody's not sure that they can have the legal capacity to sign a power of attorney document, the supported decision-making agreement is, sometimes we refer to it inelegantly as a power of attorney light. It is designed for an individual with a disability. And if they are in my office and I say, when you go to the doctor's office, is it helpful, or do you like for your mom to be there? Is it helpful if the doctor needs you to make some decisions? Is it helpful for your mom to be there and help, or your dad, or both, or sibling, or whomever is their supporter? If I feel like they can understand what I'm saying, and they understand generally that, when I'm in the doctor's office, it's confusing for all of us. We all need a supporter in the doctor's office, frankly. But if they want to have that and they want to, sign that document, then it is a slightly lower level of capacity than entering into a legal document like a power of attorney document. And it's all also more limited, right? So the power of attorney document is very broad. That person can literally act for the person in every way. Supported decision-making agreement is you're making decisions together. And so I have been in the scenario where, we're at a hospital, individual is being treated, individual with Down syndrome, and has a supported decision-making agreement. And I'm talking to the attorneys at the hospital, and they're saying, but if they decide to walk out the door, they can, right? Because they're an adult, they're not under guardianship. They have a supported decision-making agreement, which they can revoke at any time, or they could disagree with their supporter. And the answer is yes, they do have that right. They're not under guardianship. And so where that leads us is, as long as that supported decision-making agreement works within the relationship between the person with the disability and the supporter, then great, let's keep using it. The day that individual maybe is declining to accept medical care that would be good for them, and now they are really a harm to themselves in a serious medical way, then you might have to go get guardianship. And then that would be really the necessity that you'd need to show the court to say, this individual was doing pretty great with the supported decision-making agreement, but now they're refusing to get treatment for cancer or something serious. And now we need to get a guardianship to protect them. And that would be a really important way to protect them, I think. So, yeah.
Asha asked, is it easy to transfer guardianship if we move from one county to another county?
From one county to another county, it's typically easier than state to state. State to state takes some time and can be a little bit different. And it just depends on the county. So if you're in a county like that has a statutory probate court, Tarrant County, Denton County, Dallas County, Travis, Harris. I may not be off the top of my head listing all the statutory probate courts in Texas, but you get the point. The big cities have statutory probate courts who sometimes have more rigorous requirements for transferring from county to county versus the county courts at law out in Parker and Hood and Ellis and some of those that are slightly less rigorous to transfer guardianships into. So it depends county to county and court to court a little bit, but it is a proceeding that's regularly done and pretty typical.
Okay, we have a question. Let's say once we get to a point where we get all in place and the first and second guardianship persons appointed for his care can't take care of my son, in the case we both might pass away, my husband and me, can the third person appointed for the guardianship be in Mexico?
So can you have a guardian who's not in the US? I think the answer is yes. It depends on the court. The court has discretion about who they appoint. So the person who has guardianship would, have a designation of successor guardianship document. And then the court, if something happened to that person, then the court would say, okay, we need to appoint a new guardian. And so that person would come before the court and say, you should appoint me. Now, I do live in Mexico. And the court would say, is there anybody else who's closer by? Or you're in Mexico, no problem. Are you going to have frequent contact with this individual? Is this a good setup? Does this work? And so that's what the court's going to have to determine. And so it's not that it's impossible. I don't think. I've not actually had it happen, but I don't think it's prohibited. I think it's just a matter of the court determining whether that was in the best interest of the individual.
Is it possible to have more than one supporter on alternative supported making agreement?
Yep, you could have several supported decision-making agreements, maybe different contexts, but definitely, parents. And of course, these things can get really complicated if parents aren't on the same page, aren't married, or have different ideas about what that adult individual could do. And so I think the benefit of being able to agree on a supporter, or at least, if both parents or supporters trying to come up with an agreement, because the alternative is letting the court decide, just like in a divorce. Letting the court decide, you don't have any control over it. If individuals can decide together, if people can be reasonable and come up with a plan, it's obviously great when you're able to avoid a court being involved with your life.
Can only one parent apply for guardianship? If both parents pass away, how do I set up my older daughter to have all rights or part rights for my daughter with disabilities?
So if you have a guardianship, you can execute a document that just says appointment of successor guardian, basically, or designation of successor guardian, and you can designate that person. And then again, that person would go before the court and if in that event.
What time frame should you obtain these things? How many months before the child turns 18 or need to wait until after they turn 18?
So, typically try to tell people to push it down the road as far as you can. Guardianship is always available. So if there's not some reason that it's absolutely necessary, try to wait, try to put it off, try a supported decision-making agreement, see if you can kick it down the road. If that's not possible, and I've had, individuals who maybe have a birth injury or something where it's clear that they're not going to have capacity when they turn 18. And it's also clear that they have significant medical issues. And so the parents are really concerned about getting guardianship immediately and there not being any gap between them turning 18 and not having the ability to handle their medical issues. In those cases, you can file for guardianship 120 days prior to the 18th birthday, and then have the hearing actually appointing the guardian, on the 18th birthday or as close as you can get. So I've done that several times because those tend to be the only guardianships that I'm willing to get into, are the ones that are really, really clear that there's medical necessity and incapacity. I end up not doing a lot of guardianships for people who have Down syndrome because most or many, and I hate to make generalizations like this, but most of our friends with Down syndrome don't necessarily need guardianship. Now, it's not across the board. We've done plenty of them. But it's always best to see if there's any way to avoid it or kick it down the road if possible.
For the supported decision-making agreement document, does the individual with special needs, do they have to be 18 or older?
Yes, good question. Yeah, they must be 18 or older to sign that. It's intended for an adult. Mhm.
Then we have some questions about people that live in different areas. So, to qualify for this grant, you must be a parent, legal guardian, or primary caregiver of an individual with Down syndrome, and you must reside in DSP&T service area, which is Tarrant, Parker, Hood, Johnson, and parts of Denton County. Unfortunately, I wish we could offer this to everybody, but because of some of the restrictions of the grants, we need to keep it into our service area. Let's see. So we're good.
But after we do this, I mean, we haven't done this particular type of clinic before. And I think that it's possible to expand it to, other organizations and that sort of thing. So we will do everything we can to share our knowledge of going through this with the ARC and other organizations that might be able to expand the reach of this kind of a clinic.
Yes, definitely. We have a question specific to a family that is the financial assistance only for citizens. And so this family is from another country and working on, let's see, guardianship for their daughter from India.
I don't believe there's anything in that restricts us, Whitney, as far as the grant is
I,
concerned.
I don't think so. I don't think so.
Certainly, guardianship is not restricted. You don't have to be a citizen to get guardianship or do your estate planning here. So there's nothing about the services that would be restrictive, and I don't expect there's anything in the grant that would be either.
Right. Where can I apply for medical power of attorney?
So, medical power of attorney is a document like a financial power of attorney or a will that would typically be in a will package. So when for anybody that qualifies for this program, we will do a full set of estate planning documents, which would include financial and medical power of attorney for you, um, and if not, then it would be, hire an attorney. It's also a statutory form. So, you can probably find a pretty good one online these days. I wouldn't guarantee that it's good. I've seen some weird forms pop out of, our AI friends right now, but some of those can work.
Yes, and then we have a question, how can I find the income limit for the legal assistance? And so when you fill out the application, you will be required to provide your latest tax return. And then we are going to be using the federal poverty guidelines to decide the sliding scale for how much financial aid we can provide and how much you would be responsible for, which we would communicate to you before you start the process, so you're aware of your financial responsibilities.
And we'd also like to know how much of a need there is. There may be a large need for Spanish-speaking attorneys here and for the program so that we can make sure we're able to provide that if it's needed. So make sure to put that in your application.
Yeah, I'm not seeing any more questions. If you have any more questions, go ahead and type them in the chat. But just like Heidi said, I'll be sending out the application as well as the questionnaire. And if Heidi, if you don't mind sharing the slideshow, I know some people requested it. I can also send that out to everybody as well. You will have 2 weeks to complete the questionnaire and application. They are due Thursday, March 5th. And I'm going to go ahead and put my email and phone number in the chat. If you have any questions or trouble with the application, please feel free to reach out. Like Heidi said, this is our first time doing this, so we have the format in place, but sometimes technology doesn't work out. So we would love any feedback throughout the process. Let's see, someone posted, if we don't have a tax return and only have unearned income like child support and disabilities, would we just provide that information? Um, yes, I think, Kim, that might be a question for you if that works for the grant.
Yes, that would work. We would just have you sign something that states that those documents are your only source of income.
All right. Any other questions?
I really appreciate everybody being here today. It's a lot of information to take in. I think it's important to just educate yourself about the whole process, whether you're applying for this program or not. But if you do, we're excited to work with you. And just let me be a resource if I can help with any questions on these items. So thanks for being here.
Yes, and thank you so much, Heidi, for partnering with us and providing your expertise. We really appreciate it, and we're so excited for this grant. And yes, thank you everyone for coming. And if you have any questions, feel free to reach out. Thank you so much.
Thanks.